for joining me back here in the studio today talking about arbitration. And before I jump into it, I want to give a shout out to all of our neighbors, friends, colleagues, countrymen, and people and loved ones and friends around the world whose economies have been decimated by the pandemic of COVID. We are thinking about you. We are sending positive thoughts and positive prayers to lift you all up, and hoping that your situations return to normal as quickly as possible so you can provide for your families and live the life you've dreamed. The thing that we are talking about this week in the practice is arbitration. And the first segment I talked a little bit about the difference between mediation and arbitration. And just a brief recap: arbitration is a completely private litigation process. It's like paying to go to court through a private process, and it's completely separate from the courts except for a few things. And in other words, it's not part of the judicial branch of the state of Texas or the United States government. We have three branches of government. We have legislative, that's Congress. We have the executive, that's the president. We have the judicial. Arbitration is completely outside of that process, but for a few things. Mediation, on the other hand, sounds very much like that. It's very similar in its name, but it is actually part of the judicial branch process, whereby parties in a federal lawsuit or a state court lawsuit may be ordered by the judge, and often are, except in criminal cases. They are ordered by the judges to attend alternative dispute resolution, that's mediation, which is a non-binding dispute resolution process. You go to so there's client A and client B, and they all go to a third person's office. We'll call him Mr. C, and Mr. C is serving as the mediator in the case, and the parties and their lawyers will meet, sometimes together, sometimes separately with the mediator, and try to come up with a deal they can live with. Because if you make a deal you can live with, it might be better as a result than the deal you get down at the courthouse. A great mediator once told me that what you get at the courthouse isn't fair. Fair is what you get in Dallas in the fall. What you get at the courthouse is reasonable, and that's all it has to be. That's all the law requires. In addition to that, down at the courthouse, you're locked into the rules of evidence, the rules of procedure, things that are specific to whatever kind of case it is, the rules of criminal procedure, the rules of civil procedure, the Texas Estates Code regarding probate matters regarding the passing of inheritances. These are things that the judge is locked into because that's what the legislature mandates. What you can do at mediation is a whole lot greater. Arbitration is a private litigation process where you are paying a third lawyer to sit as judge, and he or she will be somebody with vast experience in either litigation or as a retired judge or former judge. Most arbitrators, you have to have a certification, and it's more along the lines of what happens in a trial as opposed to what happens in mediation, where the mediator is pushing people to compromise.